As I like to do, kind of reset the table just a bit. You've heard me talk certainly now about liability. When there is a lawsuit filed, when a plaintiff sues a defendant, there has to be a basis upon which that lawsuit is grounded. What is the legal relationship that allows for the plaintiff to complain and seek damages from the defendant or defendants? And as we have talked about, that legal relationship, the duty, the legal obligation that exists between a defendant and a plaintiff that would give rise to a plaintiff claiming unlawful actions resulting in harm and resulting in a lawsuit, because that's what it takes. A lawsuit is brought when someone points the finger at another or others and says, you acted unlawfully and I was harmed as a result of those unlawful actions. But the idea of what would constitute that legal obligation existing in the first place, what is it that caused the defendant to owe a legal duty to the plaintiff? It's going to be grounded either in a statute that establishes a legal obligation, or there is going to be a contractual relationship between the parties that establishes a legal relationship, or much more broadly, the legal relationship is going to be one that is covered universally through what we call in this review the law of torts, where we have a legal obligation that exists not necessarily because there's a statute that tells us how or how we are not to behave, and certainly not because there's a contract that puts parameters around the relationship, but instead because there is a recognition that is being part of a society, that our behavior can put others in harm's way. When we develop a product and we put it out into the stream of commerce, and that product is faultily designed or faultily manufactured, and there is harm that occurs as a result, we face liability, we face exposure. I've got a client that does work for government, works on government projects, bids on the ability to provide services to government on and in those contracts, makes a decent amount of money on those government contracts. As a requirement of bidding on those government contracts, my client has to have a certain set insurance in place to cover the work that is performed. Those insurance contracts, the bids for the government work, are all a matter of public record. As my client points out from time to time, that kind of puts a target on its back, because everyone knows that if they get awarded the contract, they've got a $5 million insurance policy. And so if something goes wrong on the project, there's that target. Hey, if we can establish that Behan's client has acted negligently, there is the possibility of tapping into that liability insurance coverage. And so there becomes a little bit of a cost-benefit analysis. Is the contract and being awarded the contract economically rewarding enough to actually pay for the insurance liability coverage that is necessary to be able to bid on the contract to begin with? When we look at liability, and we will continue to focus in on liability as we move ultimately into the association of businesses and the establishment of businesses, because risk aversion is certainly in the cost associated with engaging in business, and liability cost is a large component of that. You don't have to look much further than, the large hotel chains and restaurant chains that spend a lot of money on loss prevention, because that's a significant component, a significant risk to the entity. When we move further into those discussions, I am going to again point out to you upon what is the basis for the claim that this defendant owed this plaintiff a legal duty that was violated. That violation of the legal duty would be what we refer to as an unlawful act. And if that unlawful act causes harm, those who are harmed could seek to be compensated. When we looked at negligence, I tried to point out to you that, again, what is significant about a negligence claim is the fact that the injured party is seeking to be awarded not just economic loss, but also non-economic loss to cover pain and suffering. And so in the latter part of this session, we're actually going to talk about the No Fault Act and how in a state like Michigan, we have notably separated out whom you're able to seek economic damages from in a automobile crash or injuries arising out of an automobile event, as opposed to those whom you're able to seek compensation in the form of money to cover pain and suffering, non-economic damages. We're not there quite yet, but we'll get there in just a short while. To reset the table, as I am in the process of doing, I'm going to go back to the lecture slides. And you're probably tired at this point in time of seeing the spectrum of fault lecture slide. And I assure you, this is the last time that I will be showing it to you in the course of our overview of torts. But what is important for you to visualize, for you to recognize, for you to see is the fact that when we are talking about liability in the form of a tort, liability that isn't grounded in the violation of a contract or breaching of a contract, and liability that could be, but most likely is not associated with the violation of a statute, where the remedies are laid out typically in the statute. But instead, this liability that is associated with an individual or a business engaging in an activity that puts others in harm's way and doesn't meet the reasonable expectations minimally of society. And so we had intentional wrongs, intentional torts, where if you are the victim of an intentional act, you will be compensated for the harm that you have sustained as a result of that intentional act. And what is a bit difficult sometimes to perhaps fully comprehend or grasp is that if you are the victim of an intentional tort, while in theory the compensation is supposed to be to make you whole, to compensate you for the harm of being a victim of the intentional tort, we do not actually require that as a prima facie piece of evidence in the case, as an element of the case. We do not require that you show objective evidence of harm. Why? Because the bad behavior, the intentional wrong that has happened to you is of such a violation of your rights that we do not require that you show how that violation of your rights has impacted you. We will presume that there was damage, and we will allow for a jury to award you what they deem to be fair, given the circumstances. When you move to not intentionally unlawful behavior, but behavior that is unlawful because it dips below the level of acceptable conduct that we as a society prescribe to a particular person or a particular activity or a particular business, we now judge behavior based upon the reasonableness of this behavior. Was the reasonableness standard established when someone was driving their vehicle? Were we all together? I would ask the class the following question, which I typically would do in the large lecture halls when I had you all with me. I would ask this question. What is the reasonable rate of speed for an individual to drive between East Lansing and, say, Detroit if they were to take I-96? And inevitably, a hand or two would go up and somebody would say 70 miles an hour or 75 miles an hour. Sometimes somebody would raise their hand and they would say 85 miles an hour. And I would, of course, have to respond by reminding all of you, you never have to admit to unlawful behavior. You can always choose to say nothing. So don't admit to exceeding the speed limit. In fact, the best thing you can do is not to exceed the speed limit. But what I would then quickly point out is that I have asked a question without giving you sufficient facts, because you can't tell me what it is to drive at a reasonable rate of speed between East Lansing and Detroit, or between Detroit and East Lansing out on I-96, without me providing you additional information. And that additional information would require me to tell you, what are the conditions? Because even if you're driving 70 miles an hour, which is lawful in most of the stretches of I-96 between East Lansing and Detroit, that would be crazy to drive 70 miles an hour if it's foggy and icy out on the expressway. So the point that I'm trying to illustrate is that when we're judging the reasonableness of behavior, we need to look at the totality of the circumstances. What is reasonable in one circumstance is not necessarily reasonable in another circumstance. And it's not just simply enough also to say, well, hey, have the rules been followed? Okay, because we apply the elements of duty, breach of duty, causation, and damage. And as I pointed out in our last session, all four elements must be met, and they must be met under the same set of circumstances for a juror or for a judge to reach the conclusion that a defendant's actions, in fact, were negligent. Let me give you an example. Let's say that you have a swimming pool and you are doing some construction work at your home. And while the construction work is being done, the fence surrounding the swimming pool is taken down. Now, the law will mandate that whenever you have a swimming pool, that swimming pool be adequately fenced in. And the reason for that is because a swimming pool is what under the law we would refer to as an attractive nuisance. And the concern is that a child or a pet could stumble upon that swimming pool and be harmed. Well, I and a few of my friends are out on the town and we drive by your home and we recognize, hey, the fence is down, the swimming pool is unguarded. Shame on you for not having the swimming pool guarded or the fence up. And so my buddies and I go and we run and jump into the pool and I'm injured. Now, because there is a statute that there is a functioning gate or fence around the pool, and there is not, so you're in violation of that statute, I don't have a cause of action against you for your unreasonableness of conduct. Now, by the way, having a pool and not having it gated or fenced in is unreasonable conduct. But your unreasonable conduct, the violation of that code, that ordinance, is not the breach of a duty to me. A 58-year-old lawyer needs to know better than to go run and jump into a pool that is unattended, whether there is a fence around it or not. So we have these parameters that are set up to help us adjudicate, judge what is reasonable behavior and what is reasonable, and what is unreasonable behavior that rises to the level of being negligent behavior. As I suggested to you during our last session, we have all from time to time acted in a way that is negligent. But fortunately, none of us, to this point at least, have been sued for the tort of negligence, because even if we have acted negligently, our behavior has not resulted in damage or harm to others. When we look at negligence, we also recognize that negligence has some application to businesses that may be classified slightly differently depending upon the business or the allegations that are made. By way of example, you've perhaps been familiar with the term malpractice. Malpractice is when a professional, a physician, an attorney, an accountant, an engineer, someone who holds a professional license, commits an act of negligence. What makes the professional who commits an act of negligence a little bit more difficult to hold accountable is that if you're going to attempt to show that a professional has acted negligently, the great likelihood is you're going to have to find another person who is a member of that profession who is going to be able to and willing to testify that this was the standard of care, this was the legal obligation that was owed by the professional defendant to another, and this is how the standard was violated. We also find that when one is seeking to hold a professional accountable in negligence, that the statute of limitations in most jurisdictions is lesser. While the statute of limitations for ordinary negligence in Michigan is a 3-year statute of limitations, if you are looking to hold a physician accountable for malpractice, the statute of limitations is a 2-year statute of limitations. And even there are certain requirements that have to be satisfied at least 6 months before you can file a lawsuit against a physician and or a hospital. When you have the desire to hold a bar or innkeeper liable for providing alcoholic beverages, there is a statute in most states that is referred to as the Dram Shop Act. And the Dram Shop statute will actually codify to whom a legal duty is owed, and it will include providing alcohol to a minor who goes out and causes injury to another, or to provide alcohol to an individual who is already inebriated, an individual who is already drunk, and providing them alcohol when they already have had too much or consumed too much. You will be liable not just if they cause harm to themselves, but to whomever else they cause harm to as a result of them being provided alcohol by you. That's why local establishments are extraordinarily tough, or try to at least be very difficult for those of you who are not of age to be able to purchase or consume alcohol as a result of their legal right to sell alcohol. When someone claims that a product harmed them and they bring a cause of action for what we refer to as a product liability claim, this can be based on the negligent manufacture of a product, the negligent or defective design of a product, or perhaps even simply the failure to warn of certain deficiencies in the product, predicated or based on how it is likely that someone may actually use the product. This is why when you get into a car, oftentimes you'll see many labels. warning the occupants of that car as to what the risks are associated, particularly with the airbags in that vehicle. Go shopping for a lawnmower, and you'll somehow underneath all of the warning labels probably find the mower, but these warning labels are there principally to ward off any potential claim that the product is negligent in its condition for not having put likely users on notice of how the instrument may bring about injury or cause harm to them. One of the issues that I do want to address with you as we look at the law of negligence is some of the defenses that exist of the law of negligence. And again, I always hesitate to move forward without, again, trying to minimize the impact of the terms that are used with great frequency within law. You've heard me say this before. I'll continue to remind you, but simply because we put a label on something doesn't in and of itself make it more complicated than it really is. And so we put the label on behavior as being negligent behavior. And really at its core, all we're talking about is fault. You know, when something bad happens and it shouldn't have happened, again, but for someone being at fault, part of what we do in law is try to determine who is at fault. And one of the challenges is to balance out what are the potential defenses that can exist to an allegation of fault. One of the defenses that oftentimes is used when someone claims that another has engaged in behavior and been harmed and tried to point the finger at them and say, well, you are responsible for what bad happened to me. One of the defenses that oftentimes will be employed is what we refer to as the assumption of the risk doctrine. You know, when you leave your house each day, you lawfully have the reasonable expectation that others in society are going to act with reasonable care for your safety and welfare. In other words, when you're riding your bicycle, when you're walking along Main Street, you have the reasonable expectation that those who are driving their cars aren't going to have their face buried in their cell phone and taking their eyes off of the road. When you go and purchase a meal at a restaurant, you have the reasonable expectation that the food will have been stored, processed, and delivered to you utilizing the most basic or minimum industry standards. That those items that needed to be refrigerated were refrigerated. That those items that needed to be cooked were properly cooked at utilizing, again, all of the reasonable safety requirements for the preparation of that meal. I have a very close family member who has celiac disease and has to eat gluten-free. And that presented a challenge from time to time, being able to find suitable meals because early on, go back 10, 15 years ago, you would find many a restaurant would not want to offer gluten-free items because they couldn't guarantee that the item wouldn't have a trace of gluten on it. Until I think there was a little bit of a development in the thought process, and there was a recognition that gluten isn't quite like, say, a peanut allergy or a oil allergy, that if you do come in contact, it can be extraordinarily serious. And so when you would find that restaurants would not want to provide gluten-free items because they were fearful that somebody might seek to hold them accountable, there was a recognition that the likelihood of that happening was very, very low, and that it's a good business practice to be able to actually provide more items that can be consumed by more individuals. One of the defenses, as I indicated, to human behavior is we recognize that when we engage in certain activities that we are taking on certain risk. I attended the very first hockey game at Munn Arena. It was in August of 1974. There were no nets up at all around the ice facility. Pucks would fly up into the crowd, and occasionally people would get hit and even hurt. Now you go into Munn Ice Arena and there's netting around the entire facility. Nets aren't, or pucks aren't flying up into the crowd. I remember attending games early at Comerica Park, and there was very little netting down the first and third base lines. Now there's netting that goes all the way down the first and third base lines. The defense historically was, well, if you go to a baseball game, if you go to a hockey game, you're assuming risk. And the risk is that the puck or the ball could leave the playing field and it could cause injury to you. Well, the difficulty with that is that as players get stronger, as the ball leaves the playing field with greater velocity, as the venues, hit you with more and more and more advertising, so that there's never a dull moment, that your eye isn't distracted looking over at some advertisement because the venue is seeking to capture more money. It became more difficult to sit back and say, well, the burden is on the consumer to assume a risk that could be so very easily minimized, if not avoided, if the venue would put up proper netting. And herein lies kind of, again, that delicate balance between who it is that is best in a position to minimize the harm that can occur in a particular circumstance. We want those who are best in a position to minimize the likelihood of harm to take what reasonable actions they can to, in fact, reduce the likelihood that others are going to be hurt, that damage is going to result. Now, the netting at Major League Baseball stadiums, and the fact that you see it now much more than even a decade or two ago, largely came about because there were some lawsuits filed, one against the New York Yankees, where a young child was seriously injured because a foul ball left the playing field. And how's a 2-year-old going to really adequately protect themselves from a ball leaving the playing field at that rate of speed? I discussed with you in the last session, but I will repeat briefly, that we allow for juries to apportion fault. When there is an accident, when there is a crash, when there is a harm that has happened to someone or their property, it is likely that the person who has been harmed might have played a small role in the harm that has occurred to them. It is certainly a circumstance where someone may be harmed and it's not their fault at all, but there's a lot of circumstances where people are hurt, and it's mostly the fault of the defendant, but it's also partly the fault of the plaintiff. I don't think I ever defended a slip and fall or trip and fall case where, even when my client, the defendant, was clearly responsible for not correcting a defect upon the premises that absolutely gave rise to and caused the trip and fall or the slip and fall. Rarely, if ever, there wasn't the circumstance where you might also say, yeah, but the plaintiff could have been looking where he or she or they were going a little bit better. And so what happens in states like Michigan is we will ask jurors to determine by a percentage how much was the fault of the plaintiff, how much was the fault of the defendant, and then what were the damages that the plaintiff is entitled to recover. And if the plaintiff is, say, 20% at fault for the accident or event that gave rise to those injuries, we will reduce the plaintiff's recovery by said 20%. I don't get into this terribly deeply in the exam questions. States handle comparative fault differently. In some states, once the plaintiff is more than 50% at fault, they're unable to recover non-economic damages. Michigan happens to be one of those states. I'm not going to hold you to that for purposes of the exam. My experience has been if a jury believes that the plaintiff is anywhere close to 50% at fault for his or her or their own accident, the jury's not going to award them anything anyways. That certainly has been my experience. The doctrine of comparative fault actually replaced the prior doctrine that existed at common law, and that was the doctrine of contributory negligence, which was a very harsh doctrine that does not exist in any state any longer. But the doctrine of contributory negligence was such that when it existed, if the plaintiff was at all at fault for his or her or their own accident, they couldn't recover anything. That was a pretty harsh doctrine, and so now we allow for jurors to determine that the plaintiff might have been at fault a bit for the accident, but all we'll do is reduce his or her or their damages proportionate to the fault associated with their actions. Some of the other defenses that exist, noteworthy is governmental immunity. To bring a tort claim against the government necessitates having the permission of the government. At common law, the adage or the thought or the belief was that you could only sue the crown with the crown's permission. And if you go back to the beginning of the course, seems like a long time ago, but if you go back to the beginning of the course, we talked about the fact that one of the functions of government is to provide us a forum for the resolution of disputes, the courts. And consistent with this is the notion that if you're going to sue and hold the government accountable in tort, you have to have the government's permission to be able to do that. And even then, typically, if you're going to claim negligence, the standard will not be simply unreasonable behavior, but it will be closer to intentional wrong. We have what is referred to in the law, the gross negligence standard, which is what is typically applicable when the allegation is that there is wrongdoing on the part of government. Now, we're going to talk about statutes that establish civil liability on the part of government officials. And so what you will typically see is you will see an entity like Michigan State University itself not be sued as frequently as, say, the president of Michigan State University or the board of trustees of Michigan State University, the members, the individuals who are acting in an official capacity. And we'll talk about that when we look at the civil rights laws. We look at employment laws. We look at the rule of business and entity liability. Some of the exceptions to governmental immunity that exist are when the government does not properly maintain a road or a building, or if the government is acting in some form of proprietary function, if the government is involved in some form of business activity. It is competing, if you will, with the general public oftentimes, and will not face the same type of, or not be entitled to the same type of protection or immunity as it would ordinarily. Take by way of example, and I hope this not to come to pass ever, but if an individual, while attending class, slips and falls in a building, it's going to be much more difficult, if not impossible, to hold a university liable, as would be the case if they were injured, say, at a collegiate sporting event to which the university is looking to recoup money. Public entities, of course, for that particular circumstance. Finally, with respect to the different types of torts, we have the third category of tort that is known as strict liability. Remember, we have intentional torts, we then have negligent torts or fault-based torts, and then we have carved out in the law what is referred to as a strict liability tort. Strict liability, by definition, is where we will find someone to be legally responsible for harm that has occurred to another without necessarily having done anything wrong. It's not predicated upon fault. It doesn't happen, and it's not utilized within the law that often. But if the wrong, if the fault, if the claim, if the tort, if the allegation is grounded successfully as a strict liability tort, then you win as a plaintiff. It's always the best legal theory if acceptable. I mean, the best legal theory in tort law is always strict liability if it is accepted by the court, because you're not then litigating fault. You just move right to the issue of damages. So the preferred category for an action would always be strict liability if the court accepts that strict liability applies, because now you're just litigating the issue of damages. Strict liability or liability without fault applies in circumstances where the defendant has intentionally engaged in what we refer to as an inherently or abnormally dangerous activity. And this is the theory behind strict liability. Number one, why would a business in particular engage in an abnormally dangerous activity? I can think of only one reason: money. If you are the producer and distributor of nitroglycerin, it's probably highly profitable. If you are one of those businesses that implodes buildings, you do so because it is probably highly profitable. Well, guess what happens when your business is imploding buildings, or your business is the production and distribution of nitroglycerin? What if your business is the refining of oil or the delivery of oil products? These are activities to which, even through no fault of yours, harm can occur to others, and that harm very well likely might be catastrophic. And so the idea in the law is that if you're going to engage in an abnormally dangerous activity, you're going to make money, but you're also going to have to be the insurer for all those whom are harmed because you have chosen to engage in that activity. So make your profits sufficiently enough, because inevitably you're going to have to pay for the damage done by your choice of engaging in that activity. Again, think about the distribution of, or the pipeline for the flow of oil. You know, there could be an earthquake, there could be a tornado, there could be what we refer to, quote unquote, as an act of God that causes a spill, or that results, I should say, in a spill. And there's a massive cleanup, and that's going to be costly. And really, no insurance is going to be adequate to fully cover the possible cleanup and exposure for the abnormally dangerous activity. And so it exists under the law for those circumstances when we don't want to litigate fault. We just are going to skip to the ultimate determination: who has to pay for this cleanup? Who has to pay for this fix? In a state like Michigan, if you own a pet and your pet unprovoked causes harm or damage to another person or their pet or their property, you are strictly liable if it's your pet. Some states utilize what is referred to as the first bite is free rule, that if you don't know that your dog or your animal has a disposition towards aggression, then until you know that, you don't face liability. Michigan is not one of those states. If you choose to, and I have got 2 wonderful dogs, but if you choose to be a pet owner, that is under the law deemed to be an abnormally dangerous activity. And if through no fault of the quote unquote victim, there is harm that occurs to that person's pet or property or person, then you will face what we refer to as strict liability in those circumstances. We're going to talk more about insurance as we move into the law of business associations, other than to, again, remind you that one of the costs of doing business is trying to manage the risk factors. What is the potential likelihood of your business being held financially accountable for harm that has occurred through your operation of that business, and how and when can you acquire insurance to cover what could be a catastrophic loss. Again, we're going to talk more about that as we move forward. It goes kind of both ways. There are certain businesses that probably pay way more for insurance, despite the fact that they don't really face much potential liability or exposure. And so sometimes it's really buying peace of mind, and that's understandable as well. My hope to practice law forever and not be sued. That's always the objective. That's always the aim. But I've always had malpractice insurance just in case somebody ever makes a claim that I could have or should have done something better than I did. Now let's move on to 3 last items that I want to touch upon for purposes of this second exam. Because to this point, we have talked about liability tied to unlawful behavior, fault. We moved slightly away from that when we talked about liability without fault in the context of a strict liability tort, the abnormally dangerous activity. But I now want to move into a slightly different discussion where we talk about exceptions to the fault-based litigation system. And notably, this is workers' compensation and no fault. And let me give you the rough overview, but I think important overview for you to understand. If you think about it, the vast majority of adults, if they're going to get injured, if they're going to be harmed in a way that doesn't kill them, it's going to be through some work-related event, or it's going to be through the operation and utilization of a motor vehicle. That's the statistics. That's what the statistics tell us. And so how do we go about, as a society, providing an organized mechanism for compensating people when they are hurt at work or in an automobile event? And how do we do this in such a way that we will not drive every insurance carrier out of business and make sure that there is adequate coverage for people that is in place for when those events happen in their lives? And at the same time, if we don't, we have a Social Security system that could become overburdened if that was where people had to turn when they got injured at work or when they got injured in an automobile accident. So what we do is we do our best to reach compromise over the coverage of damages that arise out of a work event or an automobile accident. And here's what we do. And it goes really back to the distinction between economic damages and non-economic damages. Let me remind you, economic damages are damages that are attributable to losses that are sustained that can be proven with certainty. Lost wages, medical bills, replacement services, fixing something that is broken. Bad event happened. Here's what it cost. Here's what it costs to make the victim whole. That's economic damages. Non-economic damages, money that is paid to compensate someone for pain and suffering. That's non-economic damages. With respect to work events, here's how it works. Pardon the pun, pardon the expression. All employers are required to have insurance policies that cover their employees. Now, there are certain exceptions. If you own your own business and you wish to be exempt from having a workers' compensation policy, that's fine. But generally speaking, if you are an employee working on behalf of another, there is a workers' compensation policy covering you as an employee. And that workers' compensation policy exists so that if there is an injury sustained arising out of the work, that there is insurance coverage to cover the economic damages that you sustain. This is the deal that is struck with the workers' compensation insurance industry. If there is a work-related injury, so long as it's not a fraudulent injury, so long as it wasn't something that someone did to themselves intentionally just to get benefits, a fraud claim. If it is a work-related injury, we will not litigate fault. Even if the person is responsible themselves for the injury, we don't care. If it's an injury that is sustained at work, the exclusive remedy for that injured worker, at least relative to their employer, is to file a workers' compensation claim, and the insurance carrier that has the policy for that employer will pay economic damages. Those economic damages will be medical bills paid, replacement services, rehabilitation services, and in most states up to 85% of wage loss. But what will not be paid when the injury is sustained through a work event is pain and suffering. There is no payment of non-economic damages. So if there is a work injury, the good news for the employee is they're going to get their economic damages paid, again, up to 85% of wage loss, even if they're at fault for the injury. And work-related injuries can be through some repetitive behavior. It can be a blunt force trauma that happens, a singular event. But there is no lawsuit filed in the courts. There is no compensation for pain and suffering. There is an insurance policy, and that insurance policy pays the economic losses sustained by the individual. And it's done through an administrative process in most states, in Michigan through the Workers' Compensation Bureau. With respect to the No-Fault Act, it's a similar type of process. If you own a car in the state of Michigan, you are required to have automobile insurance. Now, Michigan is a no-fault state. What does that mean? Well, again, we separate economic from non-economic damages. When you have automobile insurance in the state of Michigan, you are insuring yourself, and if you are the head of household, all those within your household for the economic damages sustained in an automobile accident, whether they are at fault or not. These are what are referred to as first-party claims. In other words, I'm driving my car. Some other driver broadsides me, destroys my car. The losses sustained with the impact on my car, be those losses buying me a new car, or even being those losses pay wage loss that I might sustain, or medical bills that I might owe, those are all going to be covered by my insurance company, my insurance carrier. I'm going to put a claim in on my insurance policy, even though I'm not at fault at all for the accident. The economic damages that I sustain, including getting a new car, are paid for by my insurance carrier. That's the no-fault act. What I'm not entitled to from my insurance carrier is pain and suffering. I don't get to bring a claim against the at-fault party under those circumstances for pain and suffering, because if I'm able to go back to work and I didn't die, then my claim is going to be pretty well limited to what did it cost, and that comes from my insurance carrier. We do not allow traditional fault-based claims to be brought in a no-fault state unless the magnitude of injury sustained by the victim in the no-fault accident or in the automobile accident rises to the level of death, serious impairment of an important body function, and or permanent disfigurement. Then and only then will we allow for that victim to bring a tort claim, a negligence claim against the at-fault party. So this limits a lot, considerably, the number of lawsuits, tort claims that are brought in a no-fault state, because what happens is people turn to their own insurance carriers, because fortunately most accidents do not result in death, serious impairment of an important body function, or permanent disfigurement. Let's go to the lecture slides. Let me forward through the lecture slides to kind of explain a little bit these concepts. Work comp, I'm gonna leave good based on the explanation that I provided to you, and I urge you, if you care to look at the lecture slides. Again, with respect to work comp, just simply know if it's a work-related event, economic damages are going to be the limitation of what is owed by the employer, and it's going to come through the insurance policy purchased by the employer. Now, for some reason, the employer doesn't have a workers' compensation insurance policy, there's penalties involved with that. It's a violation of the law, and you can then sue the employer for compensation beyond simply economic damages. With respect to the No-Fault Act or states like Michigan that are what we refer to as a no-fault state, again, what you do is you insure yourself with respect to economic losses, and then you have insurance to cover any non-economic losses that your behavior might have caused if you are the person that is at fault for the accident, what we would refer to as a traditional tort claim. Non-no-fault states, when there is an automobile accident, people sue the at-fault party, and there is a determination of fault. In Michigan and in non-no-fault states, we don't do that. What we do is when there is a crash, when there is an impact, when there is an event, all of the parties in that accident turn to their own insurance companies to cover the economic losses. And they don't get to the question of who's at fault in most circumstances. And the reason for that is the only time that we litigate the issue of fault is if the threshold allows for a determination of who's at fault, and the threshold isn't met unless, as you look on this lecture slide, there has been death, permanent disfigurement or scarring, and or a significant impairment of an important body function. Now, if one of these three or all of these three or any combination of these three thresholds are met, we will then allow for there to be a determination of fault, and the at-fault party can be held responsible for the paying and payment of non-economic damages. And that's where you'll have an insurance policy in place to cover you in the event that your behavior causes someone to die or suffer a serious impairment of an important body function or a permanent disfigurement. I wanted to introduce you to these concepts, not a lot on the exam relative to the No Fault Act, but in as much as you're attending school in Michigan, many of you are Michigan residents, many of you hopefully will stay in Michigan, it's important to start to understand these concepts and certainly not be afraid of them. The last issue that I want to talk about in this topic, the topic of tort liability, is to draw to your attention the distinction between direct liability and non-direct liability, or what we refer to as imputed liability. Let me be very clear about this next point. We are always responsible for our unlawful acts. We are always responsible for our unlawful acts. The question becomes, when can our unlawful acts also result in someone else being responsible as well as us? And largely this happens when we are in a employment relationship. If I am a waiter at a restaurant and I drop a tray of food onto the head of an unsuspecting patron, the likelihood is I have acted negligently. I have probably put too much onto that tray. I have lost balance and I have dropped that tray onto the head of that patron. I'm at fault. But who else is going to be at fault? Who else is going to be responsible? The likelihood is my employer, because we will impute liability, meaning we will hold someone else responsible for the actions of another. And largely this is tied to finances. If I'm the waiter that drops a tray of food on the head of a patron, I'm getting paid X amount of dollars an hour in tips, perhaps, if I don't have to pool those tips. But my service, my actions, my work is benefiting the employer, who's probably making a lot of money. So the injured patron can sue me and can sue my employer for my conduct. My liability is direct liability. My employer's liability is what we refer to as imputed liability, when we hold someone responsible for the acts of another. Sometimes we refer to this as an agency relationship. It is why in certain types of businesses will try to outsource their work to independent contractors. Because if I have a delivery person delivering my widgets and I hire that delivery person, I'm responsible for any acts of negligence that that person is engaged in while delivering my widgets. But if I hire UPS to deliver my widgets for me and they engage in some unlawful behavior, that's on them, not on me. The concept of direct liability, or what we refer to as imputed liability, isn't without some additional parameters. Because good defense lawyers would always make the argument, hey, I never told my employee to go out and act unlawfully. I never told my employee to go out and commit negligence. So they were on their own when they acted unlawfully. Only those who do what I tell them to do are doing what I have required of my employees. That would always be a defense strategy. Well, recognizing that, we also will hold employees, agents, if you will, responsible when they are on a minor departure from the behavior that is consistent with employment. If there is a major departure from the behavior of the employee, we will not impute liability. But if there is just a minor departure, if there is a minor deviation, what we would refer to as a detour, we will impute liability onto the employer. If it's an out and out frolic, if it is a out and out abrogation in total of what the employee was supposed to be doing, then it really wouldn't be fair to impute liability. Just again, some terms that I wanted to get you a little bit familiar with, and that we'll see more of as we move into business associations after taking a little bit of a minor detour into the law of property. What you'll find is that in taking the exam questions on tort, a lot of it's process of elimination. Make sure that you always know why options 2, 3, and 4, the ones that you're not selecting, are wrong. Select the best option. That's going to get you the right answer the vast majority of the time. If you're one of those people that likes to know exactly what the correct answer is and be able to pull it out of options and know with certainty that you are accurate, then you're going to love property law, because that's what's coming up next. And property law is probably as mathematical and precise an area of law as we have. By definition, that's really what property law is. Tort law is not that way. And so what you have to do is you have to know the rules, and you have to apply those rules with as much logic as hopefully that you can. And